live, Senator.
Okay. Good morning, everybody. Good morning, committee members, Ms. Johnson, and members of the public. We're going to spend, I'd say, the next 45 minutes or so trying to understand more fully the rationale behind the governor's veto of H 159. 157, excuse me, and see where we can go from there. I think there was some message from the governor that there may be an alternative path forward. We want to talk a little bit about that. Obviously, the bill is up for an override at any day in the House. We don't know what that will yield, but to the extent there's a need to do something other than an override, we want to look into what that might be. So with that, Attorney Johnson, if you would like to take us on whatever direction you want in discussing the governor's thinking on the veto that he issued on last Thursday. Thank you for being here.
Well, thank you. Thank you. Good morning, Chair Sorokin and committee members. Thank you for inviting me today. For the record, I'm Jay Pershing Johnson, Governor Scott's legal counsel. And if you don't mind, I'm going to read some remarks at first to keep my thoughts in order, and then I'm happy, or if you wish to interrupt, just let me know. But I'm happy to answer questions. Okay. So first, I guess I'd just like to start by saying there's nothing in this bill about consumer protection that we don't already have the tools to do. It charges small businesses a fee to get on a list and then penalizes them if they fail to do so. Unlike most other regulated professions, it requires insurance and a written contract for jobs over $3,500. It actually intentionally targets small businesses. Many will retire, many will go to larger companies, and the guy you used to call for sheetrocking or painting or maybe some help with carpentry, that person will no longer be in business. You won't be able to get your work done by a larger company because your jobs are too small. And the scammers and the fleecers aren't going anywhere. As the Sunrise report notes, regulation cannot frighten criminals out of criminality or provide compensation to victims of crime. It also notes we already have a robust criminal law on home improvement fraud. We already have a home improvement fraud registry. I think the link maybe to that needs to be updated, but you can find it if you Google it. And the notes, and the report also notes the issue is repeat offenders. So not new entrants, but the law doesn't address competence. The issue for consumers, it appears, is repeat offenders. We also have a consumer protection division in the Office of the Attorney General with broad authority to go after fleecers and scammers. What we don't appear to be doing is robustly pursuing the legal remedies we have now. For 5 years, we've focused on removing and reducing barriers to entry to any number of professions. We've tried to facilitate entry into Vermont's professions for new Americans, women and minority-owned businesses, and veterans, as well as those looking to relocate to Vermont. With this bill, the legislature has decided it's time to build barriers to entry for the sole proprietor home improvement businesses in the state. I want to note the Sunrise report on which this legislation relies does not quantify the economic benefit of the industry, either as a whole or to disadvantaged communities or businesses. Yet, it may significantly reduce an entire sector. The report also does not claim to have a handle on the nature and extent of the problem. It begins with a caveat that it could be either grossly overestimating or grossly underestimating the economic harm. While it determines there is a problem, it concedes the particular economic cost cannot be determined from available data. The list of small businesses potentially affected by H-157 is exhaustive. Any work on any residence of 4 or fewer units to build, demolish, or alter, including interior and exterior construction, renovation, and repair, painting, paving, roofing, weatherization, installation of heating, plumbing, solar, electrical, water, or wastewater systems, and other activities specified by rule. So yet to come, I'm assuming these could be excavation, HVAC installers, technicians, masons, sheetrock installers, tapers, chimney repair, cabinetry, window and door installation, security alarm installers, wood burning and propane stove installation, local handymen. I think the list could go on. I mean, I just think pretty much of local contractors who I have hired in the time that, the 20 years or so that I've been in Vermont. It may come as a surprise to well drillers that they are subject to regulation not under just one regulatory scheme enacted in 2021, but this one as well. The good news for architects, engineers, plumbers, electricians, and landscapers is that they are not bound by the contract or insurance requirements. As the governor said, he supports policies that will help small businesses succeed and grow. To quote from his veto message, this bill has the potential to undermine and weaken a large number of Vermont's small businesses, small local residential contractors, at a time when we all agree we must prioritize new and revitalized housing. More specifically, this bill favors larger and more established businesses at the expense of small entry-level businesses by imposing, by law, specific contract and insurance requirements that many of the smaller businesses will not be able to meet. Such specific requirements are rarely, if ever, imposed on other professions. Ultimately, these provisions harm small businesses, which could lead to closures, and they harm consumers through higher costs and fewer options for making needed repairs. Thank you.
Thank you very much for that. I hope I'm not getting my veto messages mixed up, but I think that there was something expressed by the governor of saying perhaps enforcement tools need to be sharpened, and there should be a path forward to get to the goal of trying to make more people whole when they are defrauded. Can you talk a little bit more about that?
Well, I mean, I think what we all probably already recognize, and it's discussed in the Sunrise report, is the fact, and I think I mentioned it in my remarks, we have, the Office of the Attorney General has a consumer protection division with broad authority to go after fraud and fraudulent activities. And on top of that, we have what I think is described in the Sunrise report as a robust criminal law, which addresses this behavior. So you have the Attorney General's office and the 14 state's attorneys. The report indicates that they are enforcing the law with some success, but the problem is repeat offenders. There are post-conviction remedies in that law, but it does not appear that those are being pursued. I'm not sure why, but the report indicates that repeat offenders is the problem. So they're not posting the bond that's required. I don't know if they're paying the fines that are imposed or if any are imposed. I don't know if they're doing criminal time in corrections. I don't know if that is being imposed. But those are all remedies allowed in the statute. I just don't know where the the remedial portion of that statute falls apart.
So let me just ask, in terms of a path forward, if there is no veto override, it sounds like you're saying the tools already exist. They need to be sharpened. If that includes a lack of resources to either of these departments to effectively prosecute, would the governor support simply just putting more money into these programs to make sure that they have the wherewithal with their existing tools to have stronger enforcement against fraud?
I don't think we understand enough about the problem to say that it's just resources and more money.
Okay, so I'm just asking you, I guess, to make an assumption. If it turns out there are legal tools, but there's no man or women power behind those tools to bring those cases, state's attorneys and attorney general, they all have uh, challenges. Everybody has challenges in terms of resources. I'm saying if we identify that that is the problem, and the governor's not seeing another path other than to use existing tools, but those tools that he wants to use cannot be used effectively because of lack of money, would the governor support infusing more money into this program of enforcement?
It's such a conditional question, and I'm really not prepared to answer it.
Another way of asking it is this issue important enough to the governor in terms of people getting hurt, that if that's the way he sees curing it, is he willing to put his money where his speech is about there is a path forward, the tools need to be sharpened. And if we discover as we dig a little deeper here today and this week forward that part of the problem here is it's just not the man or woman power to do these kinds of cases, even though they theoretically exist in law, will the governor stand with us to fix this problem?
Again, I can't answer that question without understanding more about what you're proposing. I mean, the thing that would be simple, I would say fix the dead link on the Attorney General's website and then provide some opportunity for education for consumers. I mean, what I'm reading in the Sunrise Report is that construction on your home is an overwhelming process. Consumers don't have enough information. They don't know who the good guys and the bad guys are. Well, there's a list of bad guys. We could perhaps make it easier for people to find that list and maybe educate people as to the fact that it actually exists and should be used as a resource. And the idea that there are a number of people on that list who are repeat offenders, it also indicates that maybe there's something else we should be doing in terms of post-conviction remedies that would seem to me not to require a whole lot of extra staffing.
Okay, thank you. I hope you can stick around till, or at least another half hour while we hear from the Attorney General and from the Secretary of State. I've asked them to go through the governor's veto message and explain to us where they think the governor is right and where they think the governor is wrong, or where you folks have a difference of opinion, so we can be better educated on how to proceed here. Obviously, we didn't get a lot of direct input from the governor's office for the 4 years we've been working on this bill, so we're doing a quick learn now. We understood at the last moment from correspondence that I personally had with your office or with Kendall that the governor would have liked to see a higher threshold. Our research showed that if we had gone to a threshold of $10,000, we would be missing 80% of the claims of fraud that had been brought to the Attorney General's attention. So unfortunately, we could not agree at that point. But at this point, I'd like to just turn it over to Chris Curtis for a response, and then to Lauren Hibbert, and then we'll bring you back on, Jay. And I'm really just looking to find if there is really a path forward here to get at the situation where Vermont, apparently, as we've been told, is a true outlier among the rest of the states in terms of protecting the public and having some oversight over this profession. So, Chris, if you can join us.
Good morning, Mr. Chair, members of the committee. I'm sorry that I missed the introductory remarks by the administration. I have standing meetings every Tuesday, and I had alerted committee staff that I would be unavailable from 9:30 to 10:30. So I think the meeting started a little earlier than I had originally anticipated. So as you know, the Attorney General has supported this legislation, and we're obviously disappointed that it has not become law. And if you want to, ask certain specific questions of our office with respect to how complaints that we do receive are handled, I'm happy to answer those. But specifically, I think, a challenge has been that there is no single home in state government for these types of complaints. So while the Consumer Assistance Program does receive hundreds of these complaints, there's a wide variety, and some are reported to local police departments, some are reported to the state's attorneys, some are criminal in nature, some are civil in nature, some are disputes as to the size and scope of certain jobs. And I think that the bill that the legislature considered really did a nice job of balancing all of the aspects of how those, first of all, how many of those complaints could be avoided through the use of a written contract so that all the parties know and understand what the terms are. And then how an administrative process could also be a deterrent and a preventive model, so that if there are non-participating bad actors who simply will not engage, they can be removed from the registry. And then just providing assurance to consumers that, yes, insurance and taxes have been paid, that these are reliable sources for consumers to go and consider as they pursue their contracting needs. And of course, the professional development among the trades themselves. So you've all considered all of those aspects as the bill has made its way through the legislature. And we think it's a balanced proposal that meets the needs of both of the contractors and the general public. It is true that Vermont, in many instances, is a leader and is often on the cutting edge of taking steps to address consumer concerns. This is a rare instance, I think, where Vermont perhaps has not been in the mainstream with where other states are going, other jurisdictions that have considered many of the same issues.
So, Chris, I'm sorry you missed Jay's testimony, most of it, but if I could sugar it down, I think one of the primary concerns she has is that we already have the tools to deal with these bad apples and we're just not using them. So I think that, and I think she specifically reflected some of the powers that the Attorney General has, and that we're not following through on use of those tools. I asked whether, is that a question of resources, or do those tools need to be sharpened, as I think the governor said, either in the veto message or elsewhere, that this act is unnecessary because the tools we have already, I guess, could be effective. I'm not sure he's saying that they are presently effective, but we should look to those tools to resolve the problem of fraud and the people who run away with your deposits and stuff like that. So if you didn't hear any of that, I'd like you, if you could respond to that.
Well, I would simply point out that not every matter is ripe for litigation. So that presumes that every matter should be essentially litigated. We have a robust mediation program, which does resolve some complaints, at least for the folks that do find our office, but not everybody does. Not everybody knows to go to the Attorney General's office. And as I mentioned earlier, people report to multiple agencies throughout state government, whether it's the local police, whether it's the state's attorney, whether it's the Attorney General's office. And so I think the benefit of having some professional oversight in one agency would be that it would require the parties to get together to resolve a matter administratively, provides an administrative solution that doesn't require the contractor to hire a lawyer to potentially defend their interests, and doesn't require, in every instance, either the homeowner to have counsel or to have state government employ counsel for an enforcement action. What the benefit of an administrative process is currently with our letter mediation in a civil matter, for example, the parties may or may not come to resolution on that. Sometimes they do, and that's great when that happens. Sometimes they can't. In the administrative context, the contractor doesn't have the choice to simply walk away and not participate, because if there's a finding that's made for non-participation, or if there's a fact that's proven, they can essentially be unregistered. That doesn't require a criminal finding in court, as the current home improvement fraud registry does. That requires a criminal conviction. So that's not going to happen in every case. So that's not going to warn consumers when there's an actor who's been non-compliant. So an administrative process handles that much more efficiently and effectively, and it's a tool in the toolbox that state government currently doesn't have.
Well, just to play devil's advocate and to try and understand the machinations here, if we were to lessen the standard for the criminal registry or change the name such that those people who don't participate, those contractors who don't participate in the proceedings, or after the mediation, it's found that there's a suggestion somehow that they were at fault in defrauding, that there be some sort of list published for that. But it doesn't for some reason rise to the level of and the cost of doing a criminal prosecution, or has the value for civil litigation. Would that list serve the same purpose as the Secretary of State's list that we've been suggesting in this bill?
Well, it's a good question. There's always the question of due process. So I think the notion is that the parties have a right to be heard. And what you get through an administrative process is different in some respects through professional regulation than it is in the context of civil or criminal litigation. So I do think that the notion that every matter can simply be handled through some form of a formal enforcement action, that might be one's perspective. I think the experience of our consumer assistance program is that not every case is ripe for the resources of state government to engage in an enforcement action. And there are various flavors of these kinds of disputes that an administrative process can more quickly, efficiently, and easily get to the bottom of than either simply having a mediation program. Of course, what we employ is a mediation program that is through, co-sponsored by the University of Vermont and the state of Vermont through the AGO, but that doesn't have the kind of robust oversight that the Office of Professional Regulation does in terms of actually getting the parties to an ultimate resolution. The only alternative that's otherwise left then to our office is litigation, an enforcement action in court, either civil court or criminal court. And then the state's attorneys, of course, are left in the position of having to pursue criminal charges when those matters are brought to them. So there's a question of the location that all of these complaints are brought, whether it's the local police, whether it's the state's attorney, whether maybe it's the Attorney General's office. This would be a way to basically put the Office of Professional Regulation in touch with all the parties right up front in those appropriate circumstances.
Okay. Senator Brock?
I wonder if you could give us some idea. Over the last several years, you've gotten apparently a huge number of complaints in this area. how many prosecutions have occurred?
That's a great question, Senator Brock, and I'll have to look into that and get back to the committee with an answer on that.
Well, I think obviously it's important to know that theoretically we have tools that can be put into play to deal with the egregious situations. And I'm really interested is, are we using the tools that we have before we go and build a new toolbox? So I'll be looking forward to the answer.
Yeah, I'll circle back to you on that.
Thank you.
Okay, Senator Clarkson.
Thanks. I'm looking at the Home Improvement Fraud Registry, which was updated in January of this year of 2022. What's discouraging is the number of really tough situations that are still where the people are still not compliant. So it's either not effective or anyway. I need to understand better how this is a tool. So it is certainly one go-to place for people who know where to go. I would argue that what we're talking about, the vast number of these complaints, 823 in the last 10 years, millions and millions of dollars. Most of them are fairly small. And you are not going to go to court and spend money litigating a case where you've lost $4,600. I mean, you're going to spend more than that in your legal fees and your time taken away from work. It is putting the burden on the consumer rather than much more productively having a sieve through which, a funnel through which you can see people who are compliant, see what their certifications are in a vast number of areas. It enables you to shop in an informed way for a contractor, which is great. Unfortunately, the tools that exist currently have failed so many of our consumers who testified in our committee. So many of them went to reports on the web or word of mouth, all of which were designed on purpose to provide disinformation to the public. And so I really think we need one funnel through which an informed consumer can go. And this is the lightest touch. We're one of 8 states that don't do this. And I think the court resources are so diminished to put this into the courts and on the cost backs of our consumers when they've already been cheated and scammed is just, to me, really a non-productive way to do this. We have an opportunity to do it in a much more productive way and in a way that also enables us to communicate with this large number of businesses. All businesses in the state are required to register with the Secretary of State's office as a business. Doesn't matter what your size is. Everybody has to, this is not onerous. Everybody's already having to register as a small business. So this is an opportunity to communicate. It's an opportunity to provide one single funnel and provide an administrative resolution, which is effective, cost effective, and efficient.
Okay, thank you. Lauren, let's turn to you. We don't have a lot of time, but you have like 10 or 15 minutes. And I'd like to hear your response to what you've heard so far and what you read in the governor's message.
Sure, thank you. For the record, Lauren Hibbert, Director of the Office of Professional Regulation. Thank you so much for having me here today. I appreciate the administration's perspective that the current tools should be bolstered or are sufficient to handle the problem. Unfortunately, when we did our Sunrise review, we just did not find that to be the case. And I personally have heard many stories. I know many of you have heard very many stories from homeowners who have never heard of the Consumer Protection Program. And perhaps that means that we need to do more outreach and knowledge on that, who find that small claims court is very intimidating to navigate and is hard to get purchase over a truly bad actor. If it's a truly bad actor, they can't even find the home contractor who stole their deposit. I've heard, unfortunately, lots of concerns about the inability of law enforcement to really put their arms around this problem. I believe it was on the House side that they heard from the SA from Addison County, who had really encountered this problem quite a bit in his community and was trying to fight it, and finding that the criminal tools were not wholly sufficient either. And what we found in our Sunrise was that if OPR was the administrative home for home contractors, that we would be able to connect people appropriately to resources, that we would be able to remove individuals from the registry if necessary, that we'd be able to provide corrective action to get somebody back into compliance with the law or the requirements, that it would really be a nexus point between a lot of, at this moment, siloed systems that are very effective when they when the consumer gets there and when it's the type of complaint that they can help. I think the Attorney General's letter mediation program is fabulous, but inherent is that to making that work is having the person on the other side of the letter respond. And if it's a true bad actor, the letter remediation program is going to be ineffective. And that's similar to the small claims court. You have to know who to serve the notice on. And if you can't find the person because he stole your deposit, then you can't utilize small claims court. And the issue continues with criminal court because we had heard a lot of testimony from homeowners. They didn't have a writing. They had no proof of the agreement, but they were out a deposit of a significant amount. And they were told that criminally there was nothing to be done. So I think this bill, in a very nuanced way, tries to solve a multitude of problems with the current systems by setting up something that would stitch the systems together and provide an administrative home for home contractors. I disagree with the expansion argument, or that this will apply to all types of professionals in homes. I think the exceptions list is well tailored. All of the folks who are licensed, certified, or registered under the Department of Public Safety are expressly exempted. And it really is narrowly tailored to the nexus of the home, meaning it needs to be attached to the home. We really, we're very careful to not include auxiliary buildings. Excavating is expressly exempted. So I think the list of who would need to be registered is well tailored. Subs are specifically not required to be registered. So I don't think that there will be an exhaustive list of people that will have to be registered. I think it's fairly well narrowly tailored. I know that there's been concern about the insurance requirement. I think the insurance requirement provides immense protection and knowledge for the consumer. And it also provides protection for the contractor. If there was one space that potentially could be compromised on, it might be insurance, but I think the benefits of insurance far outweigh the cost to the small home contractor or to the small home contracting business. And the writing requirement is essential. What we heard in our Sunrise, both with the criminal process, with the small claims process, and with the consumer protection process, is that if there's a lack of a writing, it makes it very hard to get to the bottom of what the two parties agreed upon. And it's becomes a she said situation. So it just is, the writing to me is the most important piece of the bill. And I understand that there's been arguments that it's too burdensome. I just would remind the committee that we will have a model contract on our website. It will be very simple, one-page model contract that is a form fillable PDF that someone could download and fill on their own, or fill it out with a pen and paper. So we would do our best to make sure that it was not burdensome to the home contractor and that it made sense to the homeowner. I'm happy to continue to discuss the benefits of the way that the bill is currently structured, but I'm also happy to think about ways that the bill could be modified if that's the direction that the committee desires to go.
Well, certainly it's the desire of the chair to not let go of this issue in one form or another after putting so much work into it and quite frankly not seeing the veto coming until the very end. But I'm not sure there is, at this point from what I'm hearing, a better way to do this. I've thought of, well, you want to put two people in the AG's Consumer Fraud Division and dedicate them exclusively to setting up a home improvement fraud center and do advertisement on TV and do all this stuff. You can spend $250,000 a year and achieve the same thing. That would be a taxpayer's expense, as opposed to right now it being in contractor's expense, which is the way we deal with every other profession in state government. One of the reasons I have a lot of faith in this bill is it comes from the Sunrise process, which I've been involved in with a number of professions, and it's not an easy threshold to get over for any profession who wants some sort of licensing or certification to get the stamp of approval from the Secretary of State's office. So they did a thorough job. They gave the lightest touch possible, and they see a lot of value. So yes, there may be other tools, and may have other ways to skin the cat, but I'm not sure we're going to find a better one. We may find one that's more to the governor's liking, but the bottom line for, I think, myself and this committee is we've got to figure out how to protect these consumers from the bad apples that are clearly out there, and which 42 other states have found a way to protect these people from. So that's a summary of my position. Senator Ron, did you have something you'd like to add?
No, I think you started to cover it, Mr. Chair, just with, it just seems in line with other states. It seems really, benign compared to the initial testimony that we heard. So I'm struggling to sort of reconcile the two. That's all. I think with many of these vetoes, it feels like, as I think you asked originally, Mr. Chair, there's not collaboration to problem solve around who is currently losing out. And we know in every district, regardless of our party affiliation or politics, many of us have had folks who've experienced this. So I just struggling with the exchange.
Okay, Senator Brock.
I'll go back to the Attorney General's office and ask the question. If this legislation were to be enacted, it seems that what we're doing right now in terms of dealing with the criminals who don't behave, who don't do what we want them to do or expect them to do, if they continue not doing it based on this bill, what will change? What will in effect make people stop doing what they're doing, and what means of punishment, if you will, particularly from a criminal perspective, will change if this bill were to pass?
Can I just interject? Oh, sorry. Well, I just want to say, my struggle with the framing of the question is that there's a net positive as well that isn't just about criminalizing more people, but having a registry that we know are good actors. And that's where I've heard a lot of actual, folks who need contractors around the state say that this would benefit them to go somewhere and look for good contractors that they know are reliable and in good standing with the state. This is actually a way to do something that's a positive instead of more criminal activity, which I don't think is necessarily an answer people want because they've already suffered some harm by then, rather than having a registry of positive players.
Well, I think the acid test of that will be, in the event this were to pass, is to look back after a year and see how many people actually have consulted the registry. And my suspicion is it would be a relatively small number compared to the number of people who actually hire home improvement contractors. But that said, my question still is one of, well, what will change?
Senator Brock, thanks for the question. I mean, currently the Attorney General's office, we don't have a comprehensive list of all contractors in the state. So that would change. There would be a comprehensive list. And then for those individuals, the Consumer Assistance Program, while theoretically somebody could make a public records request and get a list of the complaints and perhaps see one or two, that pop up that might be in their town to be wary of. That has to be an affirmative request. So there wouldn't be a place besides that and the home improvement fraud registry, which requires a criminal conviction. There's no place for the average homeowner to go to do that without, probably what is not a natural instinct for most consumers to make a public records request to say, okay, I'm going to try to canvass anything that's in my county and try to see where the complaints may have been. So that would be different as well. And then again, to your point, you asked, with respect to criminal activity, what would be different? And again, an administrative process is fundamentally different than the tools that are currently in play, which is either voluntary mediation at kind of the lowest form of reconciliation, or a civil enforcement action, which might be a Consumer Protection Act violation, which does require a certain set of facts to establish that, or a criminal conviction, which is what would land somebody on the home improvement fraud registry. So those are the tools that are currently at the disposal of the state or of consumers. What this does is add another element, another dimension, as you've heard. So it's fundamentally different. It would create a different process. I will defer to OPR to describe that process for the committee if you have additional questions about that. But I do think that it provides another way. And so it's fundamentally different than the tools that are currently available to consumers. And that is one of the benefits of the bill as it is currently constructed.
So just to follow up on that, Chris, let's use a real life example. Let's assume this law was in effect and a consumer who had a classic case of being defrauded, a deposit given over and the work not being done. And the person picks up the phone and calls the Secretary of State and the Attorney General. What happens with both of those calls?
So I can say on our end, knowing that the Office of Professional Regulation is there and that is now the conduit for a process like that, it is very likely that our consumer assistance program would hear the complainant, log the complaint, and then refer that complaint to the Office of Professional Regulation for the administrative process, and would alert the homeowner to that process as available to them.
Okay, so now I turn it over to Lauren. You get this referral, you already got a call as well, but you get the referral. What then is put in motion at that point?
So we would lodge a complaint and then we would screen that complaint. I would presume that we would screen it in. We then would investigate that complaint. We have 5 criminal investigators, 2 civil investigators. So depending on if it was criminal in nature, we would assign a criminal investigator. We would gather documents from the homeowner and from the home contractor. We would make sure that they were on the registry. And then we would refer those documents to a prosecution team in our office for possible administrative action to restrict or remove the registration from the home contractor. If it's criminal, then the home contractor would receive a citation and we would deliver that criminal case plus the citation to the local SA's office. And then if that homeowner was seeking restitution of their money, we would work with the AG's office through the letter remediation program or help them get to small claims court or, depending on the value, to civil court.
Okay. So I'm turning it back over to Chris. Let's assume this law doesn't pass, it's not in existence. What happens differently over at the AG's office with this complaint from what Lauren just explained she'd be able to deal with?
Yeah, so if it's a question of a security deposit, like somebody paid the deposit and then the contractor didn't show up, so it's essentially a theft, that's a criminal matter. So our office is set up to, we don't prosecute criminal matters in the consumer protection unit. We're a civil matter, so that matter would get referred to the state's attorney's office for criminal prosecution or for investigation and criminal prosecution.
Have there been a plethora of cases of that nature brought by the state's attorneys?
I'll let Ms. Hibbert describe the Sunrise review process, but I do recall that both in testimony before committees in the legislature, and I think through the Sunrise review process, there was either testimony taken or perhaps maybe written testimony from state's attorneys describing the benefit to their offices of having an administrative process to help deal with these kinds of complaints. Whether it's doing the investigatory part first and saving their offices the time and effort of that investigation so it tees up for a criminal enforcement action, or whether it's that the Office of Professional Regulation could simply resolve the matter administratively, either through compliance or removing someone from the registry, for example. My understanding was that would be a net benefit from the perspective of at least some state's attorneys who did weigh in with the process.
And may I just add, Mr. Chair, that the state's attorney's resources are pretty compressed at the moment as well. I know of at least one state's attorney who has no investigators. So, investigators are an assumption here that may not exist when we talk about resources.
Well, it sounds like through the fee and through the establishment of new positions and through the new registration system, tying this profession into OPR practically allows more intervention to resolve the situation. It doesn't sound, do you have, when you get one of these cases, do you have the ability right now to assign an investigator to the case? Do you do that in every case? Do you try and bring the parties together other than letters going back and forth? It sounds like it would be a much more robust situation at OPR, both on the preventative end and the enforcement end of what, compared to what you do now. And my original question was, if we didn't want to reinvent the wheel, even though we think it's a tried and true process over at OPR, and they have the collective resources to do it well, and they can share investigators for these kinds of things, is it also possible just to give you more resources and have you do the same thing that's being suggested in this bill?
So just a quick question. So if you mean the same thing, meaning, currently we don't have regulatory oversight of the profession. So we don't, the Attorney General's we enforce the laws of the state of Vermont. That's what we're tasked with. The CAP program is a mediation program. So it's designed to, alert a business when there's a consumer complaint and try to rectify that complaint to the satisfaction of both parties if an accord can be reached. But that is sometimes effective, and that's great when that resolution happens. It's not always effective. And then the question is, with respect to enforcement, are we left with simply litigation as the answer? And that may or may not be appropriate in every case. So if the notion is that simply providing attorneys to do enforcement work, that might deal with more enforcement actions in the litigation context, but it doesn't necessarily provide regulatory oversight or an administrative mechanism to reach what might be a different result, and that might be more efficient, both in terms of time and money for the parties. So I guess the question might be, if you're contemplating simply amending the bill to put all of those elements into the Attorney General's office, I mean, that's not something we had heretofore contemplated. That would be a pretty remarkable shift in terms of professional oversight of that body. I think it seems to me it would be unusual in state government where we already have an Office of Professional Regulation to kind of take this one profession and then try to have the Attorney General's office provide kind of a regulatory complement. That would just be very, very different than any way our office has heretofore functioned.
Okay, so I guess I'm just going back to where I started, where I'm picking up that I think there's some acknowledgement by the governor that this is not the best system we have right now, but the tools could be sharpened and we might not need a new bureaucracy. I'm just trying to peel back the onion on that as to what that would look like. Maybe we need further discussions as to what the governor's thinking when he says that and specifics about that. I'm skeptical that there is a better system that can solve this rather than the Sunrise Report. Certainly that's the traditional way we deal with all our professions and trades, and most states do, in terms of the preventative nature of having a title of registered, certified, or licensed with minimum requirements. And over time, people tend to attribute importance to those titles in terms of their selection. So that's sort of the preventative nature. So I'm just going to go back to Lauren and Jay and see if you have any final words at this point. Lauren?
I think the only piece that I would add is back to Senator Ron Hinsdale's comment. There's some good here as well. I think, when COVID happened, my office was contacted for almost every profession to get word out about the changing requirements for the profession with the lockdown and then with the reopening. We were contacted about home contractors and asked, can we get information out to the home contractors? We were contacted by ACCB for that. We were contacted by the Small Business Administration about loans. We really couldn't provide the same resources that we could for other professions. And then the other piece that hasn't been discussed today, but I just do think is really important, is the certifications. And we've heard from many contractors and consumers that the certifications, the voluntary certifications that would ensure competence would add significant value to the marketplace and are desired by home contractors, large and small. And I also think the registry would provide equal access to information on trainings, on resources at the state level to home contractors. So I think there's value to the registry. Again, the writing requirement is the most crucial part of the bill. And I think insurance gives protection to home contractors and to homeowners. And I see this as stitching together processes that, while they may work in isolation, are not working on a global level to solve this really critical problem for Vermonters, and something that we need to address. So I see the home contractor registry as crucial to that. And I'm hopeful that there is a path forward for it, particularly with the large amount of federal funds that are going to be used in our housing market over the next couple of years.
Okay, thank you. So, Attorney Johnson, I just want to end up by saying this, and you can go in any direction you want in your closing remarks, but it's just the way of the world that it's easy to look at a proposal and pick it apart and find shortcomings in it. You've done that in some very general terms. I would appreciate some more specifics, but more important than that, you recognize that there is a problem here and that there may be different ways of approaching it, sharpen the tools, as you say. I, for one, in this committee would very much like to hear specifics from you, what a bill or what a change would look like that would get at that problem, and not just be a naysayer from the outside saying what you've done is not good enough or right, but have some suggestion where we could work together on a solution that meets the goals here. And obviously, it would be great if we could have that in a, assuming the bill does not get overridden, if we could have that in a, within the next few weeks, so we can go back to work on this problem, because we are going to go back to work on this problem.
Well, thank you, Senator. I guess, first of all, in order to address that question, I would really think that we have to have a better understanding of what exactly the goals of the legislation are. I've heard two things. One would be go after the very bad actors, which this would not address at all. The other would be that we need more consumer education, and that this list would just be a resource so that consumers can shop in an informed way. But that actually is not true either, because there is no, and your findings concede, there is no requirement for competence. You just need to pay your fee and get on the list and get some insurance. And so I think in doing this, in determining that we are doing contractors a favor, we are not looking at the impacts on the industry as a whole or the impacts on consumers who rely on it. So I would say that if we were working on it and we were talking about the need for better consumer education, that doesn't necessarily mean an entire new regulatory structure. So I guess that I would have to say, if we were going to work on this bill, we would have to be doing it with those things in mind, and not simply a very, very focused look on what everybody is determining to either be the very, very bad actors or what the industry itself needs. I know that you're working with trade associations who represent much larger contractors. They obviously have nothing to worry about in this bill. And in fact, those organizations who offer certifications will get paid to do it. What's not to like? So I think that really what we need to understand more is the impact on the smaller businesses, the barriers to entry in an area where, small business owners, women, minorities, new Americans, new entrants to the state, people who can pick up a hammer with some experience, actually can perform the work, but then need to be on a registry. And if you're simply not on the registry, could be penalized. You don't even need a claim of wrongdoing at that point. You just need a claim that they're not on the registry. That claim, it seems to me, could be made by a contractor, a larger contractor, who's underbid by a local guy or female-owned business. It seems to me we're just not looking at the impacts on the small business aspects of this issue, other than the idea that they're all out there harming consumers, and I just don't think that's the case.
Okay, well, I thank you for that. It's a fair enough answer. What we will do is get you a letter outlining the things we're trying to achieve in this bill, and you can take that letter and you can say, we don't agree that this is a problem or this part is a problem, whatever you want to do with that letter in terms of how much of it you accept what we're after. And for those things where you agree that there is a problem where tools need to be sharpened, we would like your ideas as to how to do that, and not just sit back and wait for us to put something out there, go through the entire process for 4 years and then have it be vetoed. So that's not, I think, the way to run a railroad, and it's really not the most judicious use of anybody's time. So we'll proceed along those lines and we'll be in touch. I do appreciate you coming in very much. Thank you very much, everybody. And we'll take unless there's anybody else has a question, or the committee members, will take a break